Alex here with part 108 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version, as the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. One video. We are one video away from my upcoming hearing. So my next video that comes out, as far as I know, I took a careful look at the schedule, is coming up. And it might take me a little bit to put that video together, so I wouldn't be surprised if you guys had to wait till the weekend to watch it. But I just wanted to keep you guys up to date on the fact that that is coming soon. And this video goes into the court's response on two things that are pending. The judge enters what I call, or what the Supreme Court calls, not just me. He enters an interlocutory order. The first deals with, I think, the discovery request that's pending on trying to get Coral Academy of Science to get the teacher served, which doesn't matter because they got her served on their own anyway as soon as they saw my motion get filed. That's what I think is in there. And then the other thing that he deals with is the Rule 11 sanctions motion filed by my ex's attorney. And as far as I know, I can't remember, we're about to go through it, but I think he is basically saying that he's going to grant her request, but that he wants her to submit an affidavit, a Brunzel affidavit. I'm not sure if he does grant it at this time, though he may grant it at the actual hearing, which we'll know for sure when we actually get into the next video. But in any event, I think at this point in time, the mindset that I was in is pretty negative. I just feel like my good intentions don't matter. Nobody cares about the suffering our son is going through. Nobody cares about the efforts that I am taking to try and help end that. And in fact, not only do they not care, but they actually want to care in the opposite direction, which is they want to find a way to punish me. And the point of this is to basically break your financial back. The court is trying to get you to stop filing papers, for better or for worse. And again, I've mentioned this a number of times, but this ties into the court's wrong-headed approach of end of filings is not end of abuse. That is one of the best videos I think that my viewers need to watch, because that goes into why the courts do stuff like this. They have this, I don't even know if I want to say short-sighted, it's just completely inane. It's so wrong. They have this idea that once people stop filing papers, they're happy. Everything's fine and the kids are okay, which is so far from the truth. People stop filing papers because they've given up on the court system. The kids are not okay. Things are not going well. But that's what these judges, specifically the judges in the family division, think. Many of them do, not all of them. But if you want to watch my breakdown of the different types of judges, definitely watch the video, Good Judge, Bad Judge. But that's where that is coming from. So I guess we should just go ahead and take a look at what the judge has filed. Here we have the order regarding Rule 11 sanctions and requiring an affidavit of attorney, and that is exactly what I suspected it was. I thought he would also address the issue regarding Coral Academy of Science, but I guess he doesn't do that at this time, or at least I can't tell that by the title of this order. Let's go straight into it. Number 1, introductory paragraph. He summarizes that he has reviewed my ex's motion for Rule 11 sanctions and attorney fees. He's reviewed my opposition. He's reviewed my ex's reply, and she has submitted to the court. What he means by that submitted is that she filed her request for submission. He goes into the next summary, which is that we share a common child, and that pursuant to the order after hearing on October 19th, 2011, we share joint physical and joint legal custody. Next, we go into the court having granted my motion to have our son attend Coral Academy of Science and directing us to set a review hearing. Again, he mentions this. strange. It's nobody's talking about this. That's why I don't understand why he keeps talking about this. Neither myself nor my ex's attorney are talking about this. We have filed so many papers. Motion, opposition, reply, motion, opposition, reply. Neither of us are talking about this, yet he keeps talking about this. It's like a strange obsession he has with the fact that we didn't set a review hearing. This happens all the time. The courts will ask parties to do a certain thing, and then they work it out on their own. And so they don't bother the court about something that they worked out on their own. It's worked out. It's done. This is not the issue right now. He just constantly brings this up. Anyway, it's funny to me because even my ex's attorney isn't trying to do anything about it. She's probably thinking the same thing. Like, what's this guy doing? We're not setting a hearing because everything's fine with the school. At least at this point it is. Next paragraph here is that I requested a modification of custody. The court set a hearing regarding custody. It's alleged that my ex is sabotaging our child's education, not just by me, but by the teacher. Next paragraph is that prior to submitting the motion, prior to the court issuing an order to set the hearing, I appeared and set the matter for a hearing. Okay, so why is he mentioning this? Of course I set the matter for a hearing prior to him making a decision. That's what the rules say. Oh, please tell me he knows about that. You know, I'm laughing I'm kind of like dismayed right now because this is an issue that not just this judge has had. There is a local rule in the Washoe County District Court rules that mandates that when you file a motion to modify custody, you file a notice to set. It is mandatory. It is in the rules. And the other judge is actually the second judge, and she does the same thing. She tries to invent her own rule, basically that's in contradiction to that local rule. And in my case, she violates the rule in a way that favors me, so I didn't appeal it because her violation of the rule didn't harm me. It harmed my ex, but my ex at that point in time had checked out. But then later on, she did the same thing to somebody else, and that person filed an appeal and won. And the Supreme Court of Nevada said, we don't care what your idea of a rule should be. We care what the rule actually says. And I remember posting that on the website, Our Nevada Judges, because that's what I do. I track all the appeals there. She got overturned on appeal for not following this local rule. So here he is. I mean, he's not necessarily, it doesn't look like he's saying that I did anything wrong. But he is saying that I don't know why it's such a great idea to underline the fact that I set a hearing prior to him telling me it was okay to do so when the local rules require you to do so. Scrolling down here, among the subpoenas filed, he goes into the multiple subpoenas that I filed. The subpoenas were issued by the clerk at my request. Some of them were subpoenas ducus tecums. Next assertion is that I filed subpoenas ducus tecums on Coral Academy of Science demanding physical addresses for the witness for the purpose of serving her. By the way, guys, this is what you're supposed to do, and this is what attorneys do too. Sometimes an attorney doesn't know where a witness is, but they know somebody who knows where the witness is. And so an attorney will file a subpoena ducus tecum requiring that particular person to turn over the information as to where that particular witness is so that they can then serve that witness. This is not anything that's weird, with the exception that, hey, Alex isn't an attorney. Why is he doing stuff that attorneys usually do, that non-attorneys usually don't do? Sometimes I feel like part of what goes into self-representation bias, which is one of the videos that I constantly point to, sometimes I feel like the judges are so used to non-attorneys not doing their research that when they see a non-attorney that is doing research, it weirds them out. And they think like I'm some kind of evil person. It's like, uh-oh, Alex is actually doing all of his research. He must be an evil father. It's this weird thing that they do where they complain, you guys need to go do your own research, you're not a lawyer. And then when you go and do that, they suspect that you're an evil person because you know too much. That is something that over time I started to suspect was true, because rather than the court being calm and comfortable with the idea of a litigant who's not an attorney having complied with the rules, they instead get extremely suspicious. And you don't get this sort of, oh, I'm so glad this guy actually went and did all the work. You get this sort of, what's this guy trying to do? Something's wrong here. He's not coming into court begging for mercy, asking what to do and asking for help. He's actually citing statutes, rules, and case law. This person must be an evil person. And that's like, I know it might sound like it's insane or crazy, but after having done this for 8 years, over time, with 2 different judges, at least in my family court, then I had all those other judges in my other cases, I started to come to the conclusion that I almost had to find this like careful balance between the two, between acting like I really didn't know what I was doing, but at the same time at least preserving all these arguments for appeal, because I needed to satisfy the Supreme Court's requirements, which is to preserve the arguments in the record so that you can appeal on them, while at the same time not making the lower judge suspicious of me. And it's a careful, delicate, fine line that you have to balance, because if you're too assertive in the lower court, then they think you're evil, and then if you're too nice and don't cite any points and authorities, then you just lose and you can't appeal. And this is one of the incredibly complicated parts about not being an attorney trying to represent yourself. Sometimes I used to tell people, you have to actually know more than an attorney to represent yourself, because if you know just as much as them, they suspect something is wrong with you and you're not a good person and you shouldn't be there. And you have to sort of like do all of these additional extra things that an attorney doesn't have to do, so that the court doesn't get too suspicious of the fact that you have done all this research. Okay, let's get off this tangent and get back to the court paper. So anyway, here we have my he's referencing the my ex's attorney's motion to quash my subpoenas ducas tecums pursuant to Rule 45C and the law. Then he goes into my filing of a motion to compel respondent to disclose the identities of those mental health providers. Then he goes into the court having noted that I failed to request leave to conduct post-decree discovery in accordance with Rule 16.21. I know that he has his own opinion as to how this needs to be done, but I have strong suspicions that the Court of Appeals or the Supreme Court of Nevada would not be amused by his little antics here. I have a suspicion that they would just overturn his decision if I filed an appeal. I still stand by the fact that it makes sense to file a motion to, for example, do request for admissions, interrogatories, and stuff like that. But when you're filing like a motion to compel or a motion to turn things over, that in and of itself satisfies 16.21, because that in and of itself is asking the court for permission to conduct that discovery. So his idea here that you need to do something before you do something, I think is a silly idea that I don't think would go very far in an appellate court. But at the same time, he's probably gaming the fact that I don't know how to do appeals, how to file appeals, especially given the fact that at this point in time I have filed one or two and they've both been affirmed. So he may be taking advantage of that fact. When we go into the hearing that's coming up, I have a strong suspicion that I'm going to get an indicator from this judge that he, in fact, is trying to violate the law on purpose, taking advantage of the fact that I'm a non-attorney. But we'll see. We're going to get into it. Next, the court is mentioning that I filed a motion requesting that the court order the Choral Academy. Okay, so he does mention this. He just doesn't have it in the title. Choral Academy to appear and show cause why it shouldn't be held in contempt of court. Also, that I filed an ex parte motion requesting that this court shorten the Academy's time to file a response. He already denied the ex parte motion. Here the court does not find any good cause. Okay, so he's citing his own order from previous. Then he goes into my ex's motion requesting sanctions, and that she states that in 2009 this court conducted in-camera review of the mental health records in order to determine if the information contained would impact child custody and visitation. She claims that the court found that my ex was not a danger. Okay, so this is an error for sure. So what he's trying to do is conflate the two different LSB Carucci prongs, and I don't know if he doesn't understand this or if he's just playing dumb. It's one of the two. He might actually know that this isn't how the law is applied, and he's just trying to do it this way to get rid of me. But the two different prongs I've talked about before, one is the change of circumstance analysis, and one is the best interest of the child analysis. He's right that I can't bring it up in the change of circumstances analysis, but he's wrong because I can bring it up in the best interest of the child analysis. He's also not mentioned the fact that he violated the way in-camera review works prior, because when a court decides that something is relevant, the court needs to turn over that particular thing that is relevant. The court can't state that something is relevant and then withhold it. That's not allowed under the law. So in all these different directions, the way that he handled the review of the mental health records is completely wrong. And to deprive me of those mental health records is, I think, at the crux of why our child suffered for so long. Because this is a case that went on for 8 years before my ex's parental rights were terminated. And mental health issues definitely underline the problems. The abuse that our son suffered was directly connected to our mental health records. So his and my ex's attorneys, it's almost like a conspiracy because it went on for so many years and for so long. This withholding of the mental health records is so inappropriate that, I mean, any attorney that I run it across just can't get their head around why this would be done. This was so wrong. And this is one of the things that leads to these types of disastrous cases, when the judges and the attorneys violate the law and then they wonder, why did this case go so wrong later on? It went wrong because you guys didn't follow the law. You have to follow it. So anyway, had they turned over these mental health records at the time that the in-camera review was conducted, this hearing may not have even happened the way that it did, because I would have had more insight about the problems that my ex's mental health raised. But for whatever reason, both the attorney and this judge decided to not turn over those records. And at this point in time, even as this case continues on several years in, they still won't turn over the records. So I've said it before and I'll say it again, that if I filed an appeal on this, this would have overturned. Mainly, it would have overturned and they would have ordered him to hold a hearing and turn over these documents. But I still think that at that hearing I would have lost. Now, even if I knew I would have lost, would I have filed an appeal knowing that later on at the evidentiary hearing I would have lost anyway? At the time, probably not, because it was so expensive and I couldn't afford it. But right now, I probably would have done it, because even though I would have eventually lost at the evidentiary hearing because the judge would have found a reason to deny the motion, I would have at least dinged him with another order reversing, which would have shown up in his record, and it would have hopefully caused him to maybe take a step back and stop violating the law in this case. Sometimes, in some of these cases, the judges have this attitude of they're just going to do whatever they want, because what are you going to do about it? And if they have that sort of idea in the back of their mind, well, what's he going to do about it? He's going to file an appeal and get it overturned. Sometimes it'll get them to actually respect you more going forward. And I actually did sense that both with this judge and the next judge. As I started to get their decisions overturned on appeal, my subsequent filings were treated with more respect and read more carefully. They would notice, hey, this is the guy that files appeals and wins. Of course, at this point in time, I'm not winning those appeals, but it won't be very long before I start to win appeal after appeal after appeal. Let's continue on. My ex claims that her attorney informed me that she was open to any proposal which would avoid motion practice, and she claims that a week later, without notice, as if I need their permission. Guys, I already talked about this. This is insane. This is, okay, watch the video, what's it called? Requirement to conduct, I think it's requirement to, I did a video where there's a local rule in District 8 that actually, okay, requirement to attempt resolution. That's the name of the video. If you go into that video, you'll actually see how that works. And this is not the way that it works. You don't need permission by your opponent's attorney to file documents. That is absolutely inappropriate. Your opponent's attorney is not the judge. They cannot block you from seeking relief. And the judge even mentioning this in this fashion is ridiculous. Next paragraph here, we have my exes claiming that the motion practice regarding the motion to quash have cost her 1.6 grand, and that I violated Rule 11B by failing to obtain lien. So this is wrong. Let's continue on. My ex is contending that I am tasked with complying with the rules of practice like any attorney, which I did do. We have a disagreement as to how that rule works, but in my opinion, I did comply with that rule. She argues that the conduct was not responsible. It's a weird word to use. Okay. Next assertion here is that she's requesting Rule 11 sanctions, and my fatally flawed request for discovery, it's not fatally flawed. It might be flawed if the Supreme Court agrees with his interpretation as to how that rule works, but it wouldn't be fatally flawed. That would be correctable. Next we have, in opposition, I argue that I emailed my ex's attorney regarding continuous absences from the school. I informed her that she was considering filing a motion, and then I claimed thereafter that I received a notice from the child's school that she had missed an additional 3 days, which is true. So guys, I told the attorney, your client has not taken our son to school. She's been absent 5 days. And I waited that 1 week and I filed because in that 1 week, she missed 1, 2, 3 more days. So she had 3 days of custody of our son, and she missed all 3 days of school in a row, just boom, 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 one after the other after the other. So it's not that I just filed a motion after a week thinking I'm going to just try and get under your skin. I filed a motion because it was getting way worse, way quick. So anyway, let's move on. Regarding the discovery requests, I'm arguing that the records are important to determine my ex's state of mind, which is obvious, and her likelihood of continuing her conduct regarding the child's school. I don't know why he needs me to tell him this. He should know this. I believe that she might have a psychological disorder impacting her decision-making abilities, and I claim that, well, he's articulating my arguments very well. He's just rejecting them. Next assertion here is that he is bringing up that I believe that my discovery motion to compel was a method of complying with 16.21, which is true. That is what I believe. And I claim that I did not construe 16.21 as a complete ban of all post-judgment. What? No, that's not what I said. I said that 16.21 requires you to ask permission to conduct discovery, and that the motion itself is satisfying that request. Moving on. I'm arguing that Rule 11 sanctions are inappropriate. I'm claiming that in child custody matters, even if a motion fails and it is meritless, such a finding would not result in sanctions. And I cite Rivero, which is true. And Rivero is correct here. His interpretation of Rivero is flat wrong. Next assertion here is that Father notes that in hindsight it might appear that my motions could not have succeeded from the start, and I believe that my requests were creative or out of the ordinary legal analysis. What? maybe out of the ordinary or creative in the sense that another attorney wouldn't do it, but it's still within the boundaries of the law. I'm asking the court to construe my work as zeal, which it is, and not frivolous, which it's not. I'm claiming that I'm arguing competing authorities regarding post-judgment discovery, preclusion. These are all good arguments that I'm making. Let's move on. Regarding the award of attorney fees, I'm arguing that my ex is not entitled to fees for her ex parte motion to quash, and I'm claiming that she's raised arguments in her motion for sanctions that the court raised sua sponte, and that my ex should not be awarded for the court's work. I'm also claiming that many of her arguments were... Okay, so I think I'm talking about all of the other things that are not connected to the 16.21 issues, which is true. And that's discussed in case law. I'm claiming that my ex has yet to pay her October, November, December support, placing her in arrears. And in conclusion, I'm arguing that I didn't intend to harass my ex. In her reply, she argues that much of the legalese and research included in my opposition is irrelevant to the issue at hand, and that the clear language of the rule barred me from conductive post-decree discovery. That same clear language requires her to comply with the safe harbor provision, which she didn't do. So moving into the next section here, she's arguing that my arguments as to why I wanted the records do not change my duty to request permission before subpoenaing the records, and I am contending that my claim there should be some mitigation regarding fees. Yeah, this is true too. Okay, so let's see if the judge actually leaves out the safe harbor provision as well. So here's the judge citing Rule 11b. So first, he's mentioning the document that's been filed. Subsection 1, not presented for any improper purpose. Subsection 2, claims, defenses, contentions are in, non-frivolous arguments. That's okay. Next, subsection 3, he goes into other factual allegations. And subsection 4, wow. So the judge omitted it too. So the portion of this rule that requires safe harbor, not only did my ex's attorney omit that language, but so did the judge. So I think that's probably purposeful that they both did that, because that would actually get in the way of her getting this award. And this is something that I do bring up at the hearing, and you guys are going to see me in action bringing this up at the hearing. And the judge's response is very telling. I remember it very vividly. But when we actually get to the hearing, I'm going to go ahead and talk about that some more. So he's going into Rule 11. He's citing the portions of the rule that work against me, and he's leaving the portions of the rule out that actually are favorable to me. So he's very selectively applying this rule. Going into the next section, here I'm opposing the imposition of sanctions by arguing that I had a basis to file the motion to modify, and that the sanctions in child custody cases aren't appropriate. It's true under Rivero. Let's see here. Here I'm claiming that I believe that I was requesting leave to conduct discovery. Yeah, that's true also. Here he's saying that I filed a motion to compel. I don't know why he keeps repeating himself. Let's continue to move on. I'm also arguing that my legal contentions in my motion to compel were zealous. Okay, again, he keeps repeating this. Moving on to my failure to request leave to conduct post-judgment discovery was not created, but rather a violation of 16.21. The majority of my other arguments were without merit. Mental health and I'm arguing because Rule 125.480 makes the mental and physical health of the parents a fact. God, I wish I would have appealed this. It's so frustrating that at the time I didn't know to do that. Okay. Next assertion here is that I did not address the privileged nature of my ex's mental health records until the opposition to a motion to quash. What? Of course not, because that's how it works. You don't bring up your opponent's arguments for them. Oh, okay. When you raise a request, your opponent opposes and then you reply. You don't anticipate your opponent's arguments and then put them in your motion. That makes no sense at all. Okay, next we have, the court is not attempting to punish me for creative or zealous arguments. I think the Supreme Court would strongly disagree, because that's what sanctions are. Punishment is, a sanction is a punishment. The Supreme Court has stated this over and over again. So by imposing a sanction, you are punishing me. You're not attempting to, but you're succeeding in doing so. The court might not be inclined to impose sanctions simply for this failure. I'm self-represented. However, in the November 27, 2012 order, the court made clear that I was without leave of the court to conduct. Again, he doesn't understand how interlocutory orders work or how appeals work. So what he's saying is that because I continued to proceed even after his November 27 order, that must be a sign that in some way, shape, or form, I am deliberately violating his command to seek leave to conduct discovery. What he doesn't understand is his order in November 27, 2012 is unchallengeable because it's an interlocutory order. So I need to actually wait to draw the case to its end to get a dispositive order before I can file an appeal. He doesn't know how that works, and a lot of judges actually don't know how that works. Most judges don't seem to understand how appeals work, and so when this kind of stuff happens, they assume that you're defying them when they don't understand that you have to continue to preserve arguments all the way through the case until its conclusion, because you can't file an appeal in the middle of that issue. You have to wait until it's completely over. And if you just start to comply with the court's ruling at that point in time, and you don't continue to preserve arguments later on, that's considered waiver in the appellate court. He doesn't know how any of this works, so he just assumes that I'm just violating his orders on purpose because I don't care. So this is a huge mistake as well. Going into the next paragraph, I'm attempting to engage in post-decree discovery in this matter without leave of the court, so he's continuing to beat a dead horse, but we'll move on. The court finds that a reasonable attorney fee incurred as a direct result of the violation is an appropriate sanction, which could provide an effective deterrence. So again, guys, deterrence is punishment. So he is actually imposing a punishment. The next paragraph here is that the court has the discretion to determine a reasonable fee in this case pursuant to Rule 11, subsection C2, but that he needs my ex's attorney to comply with Brunzel v. Golden Gate. This is the Brunzel affidavit that I've talked about a couple of times in the past. The court cannot award attorney fees unless she complies with Brunzel, and Brunzel requires her to file an affidavit that includes very specific things within that affidavit so that the court can award the fees. Moving on. Through counsel, my ex has provided copies of her billing statements, but she didn't comply with the Brunzel factor. She didn't file that affidavit. So he's basically going to award fees, but he's waiting for her to file that affidavit. I'm going to go ahead and scroll further down. We have the Rule 5 certificate of mailing, which indicates that this judge mailed this document to me. And I think at this point in time, we can move on. Going into the aftermath, I didn't file anything, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have spent like maybe 15 minutes reviewing this because it really doesn't impose any additional work on her in and of itself. She does have to prepare an affidavit, but I'd rather put that time that she puts into that affidavit into the actual affidavit when she files it later on. So since she hasn't filed that yet, I'm just going to leave it at 15 minutes just to review the order, and that's going to come to $62.50 in attorney fees for my ex because we're using the $250 an hour rate. And again, as with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.